In the Anglo-Saxon and Anglo-Norman period, there were certainly individuals who had a good knowledge of the law who were able to bring their expertise to bear on a case. We know during the Pendon Heath trial, at least we're told, that Ethelric, a former bishop, was wheeled to court in a cart to bring his legal expertise to bear on the dispute. And also the Abingdon Chronicle mentions the fact that during the Anglo-Norman period, the abbey retained certain English pleaders, Causidici, who were able to protect and represent the abbey in various legal disputes. And while these people were associated with the abbey, no one dared oppose them in any legal matter. And it's not until the 12th and particularly the 13th centuries when the legal profession began to emerge as a profession, as a sort of a regulated, formal body of individuals practicing law. Although this really began to happen in the 13th century, throughout the 12th century, and certainly as common law records, the records of the King's Courts begin to survive at the very end of the 12th century, we see family members of litigants being appointed as attorneys. Now these were really just to stand in the place of the litigant. And then later on in the 13th century, we see the emergence of sergeants. Now, sergeants actually represented their client as pleaders. They made formal legal arguments in court, whereas attorneys simply kind of stood in, represented the principal, often at procedural stages, such as someone having to be present at a particular moment in court, for whatever it might be. So the sergeants became the most respected of the legal professionals of the period. And so apprentices who hoped to obtain the rank of sergeant were able to learn their craft in the Inns of Court in London. And these Inns of Court had been established to provide hospitality and lodgings for lawyers, and also to provide formal legal education. They provided the most part of legal education for English lawyers, whereas Roman law, the civil law, was taught in universities. English lawyers tended to learn their law through education at the Inns of Court.
You see a very similar picture to the English common law lawyers with the legal practitioners in the English ecclesiastical courts as well. So at the start of the 12th century, many litigants would self-represent, or they would hire someone from outside the court who had legal training who might be able to help them, but it was a very informal system. They were also using proctors, which is the same as the attorney as well. They have someone who appears in court on their behalf. But there was no training requirement imposed on them, and the representation was often more, I think, a matter of convenience than one of seeking legal expertise. But in order for the courts to operate smoothly and for litigants to make the best use of these courts, as the procedure became more complex, legal representation was needed. And this is even noted in some of the procedural treatises. For example, in De Addendo, which is from somewhere between 1140 and 1170, it's noted that the assistance of legal professionals was necessary for the parties, and judges should provide this, or if needed, they should provide better legal assistance for those that didn't have it. From about 1190 on, the study of canon law becomes available at new English universities, and paid canon law experts start to be treated as members of a profession. Advocates were at the top of these professions, and they advised litigants as well as judges, and they kind of functioned simultaneously as legal counselors and as courtroom pleaders, and these two roles were almost inseparable. And they also served as assessors or as legal advisors to the judges. So when a judge pronounced his decision, they almost invariably took the precaution of stating that they had consulted with legal experts, the juris parity, and they had arrived at their decision following this discussion. Mm-hmm. Proctors were much less well trained than advocates at the start of the century, certainly, but they were more familiar with the practicalities of cases, and as I said, they appeared in court on behalf of their clients. Legal training wasn't required, but some of them are actually referred to as magister, so it's quite likely that you would find somebody who had been to university for at least a little bit to represent you in court. There's a bit of ambiguity in the profession as well at the time. between proctors and advocates. Certainly in the inferior courts, there don't seem to be many lines between the two professions, but certainly at the provincial level, there's a clear distinction about who can do what. The appearance of an increased number of legal experts representing clients in these church courts led to the imposition of educational and professional requirements on both proctors and advocates near the end of the 13th century. The Council of Lambeth in 1281 has Archbishop Peckham complaining about poorly trained advocates practicing law and impeding judicial process. And for this reason, the canons of the council established that one had to have attended lectures in canon and civil law both for 3 years at least before practicing in the courts.